brought along a letter that I sent to Governor Walker last week, and I'm not going to read you the entire letter. I'll read you a quote that he said, though, in August of last year. Quote, "It's in our best interest to work across party lines. Bob Jauch is the senator from the area affected. He wants the same sort of balance that we want to create, representing the same constituents in the Northwest. And he wants to make sure for local governments, local tribal governments, for others interested, that we're preserving natural resources there in a way that's long-term sustainable." Every once in a while, he says something good about me, and I've said good things about him. But I think it's important to remind people of that statement, because it is at the heart of the need for us to work together, not just to be fighting at each other, but rather cooperating with each other. And there's been an awful lot of comments that have been made about mining that have been designed to inflame people, not inform people, and that have perpetuated conflict rather than compromise. I also reminded him that in 1 year ago, the Gogebic Taconite Mining Company ran a one-page ad. In that ad, it said, "Regulatory framework means certainty." So this is what the company was looking for. "Our research has persuaded us that Wisconsin could and should clarify its regulatory framework in order to attract jobs and investment in the iron mining sector." Then it went on to say, "Minnesota and Michigan, which host all of the nation's iron mining industry, have comprehensive requirements for mining permits and demand a full environmental impact statement." They went on to say, "They also wisely recognize the major differences between non-ferrous sulfide mines that use chemicals and ferrous mines that rely on water and magnets in their processing. In both states, the time frame for permitting is shorter and the process more certain. We are encouraging legislative action here in Wisconsin and hope you will support these efforts to make sure that Wisconsin has appropriate environmental requirements and improves its ability to attract business investors to northern Wisconsin." That is what the company asked for. What the company asked for was timelines, streamlined process, something that is predictable, something that is well-defined so that the process wouldn't go on for 8 or 9 years like Crandon. I want to remind you that Ladysmith was permitted in 2.5 years. So it's the same Department of Natural Resources that permitted a mine in 2.5 years under a regulatory framework that is being criticized for taking too long. Having said that, this law was written 35 years ago. And clearly 35-year-old laws deserve to be updated to make sure that they are current, more workable, fair, and flexible. I've been committed for over 1.5 years to writing that kind of bill. Point number 2, that there's a lot of political games being played on the mining issue. Well, maybe they are, but they're not being played by me. I did what people yearn for. Senator Schultz and I did what people didn't think was possible, and that is to have a Republican from southwestern Wisconsin work with a Democrat from northwestern Wisconsin, not on a resolution honoring their favorite football team or their sports hero, but in fact sponsoring a very common sense piece of legislation that responds to what this company asked for. It creates timelines that are workable and real. So we have a 270-day period to do an environmental impact statement, which might be sufficient for a small mine. It wouldn't be sufficient for the Gogebic project, the Pinocchio Mine project. So we have an off-ramp in there that says the Corps of Engineers, who does these mining permits, who also issues permits, and does the environmental impact statement, would work with the state of Wisconsin to determine how long it's going to take. If you don't have that cooperation, it means you will have 2 permits, or two environmental impact statements. One by the Corps, one by the state. Both of them are costly and it takes longer time. So you have to have them working together. So that's number 1. After the environmental impact statement, we have a 270-day period of time. We think that's sufficient time to finish work on a smaller mine project. We include unlimited off-ramps for a company. In other words, if Gogebic Taconite found that their hydrological plan didn't work, their modeling wasn't correct, they could say, we need to go back to the drawing board, because the goal is to get it right. They could work out a timeline on the pause. So they both say, all right, let's take 4 months or 6 months. That is not a pause because the regulatory agency's dragging their feet. It's because the company and the department want to make sure it gets done correctly. So off-ramps are very, very important, and they are done in Minnesota. The company refers to the need to look like Minnesota. Senator Schultz and my proposal mirrors the best practices in Minnesota. There is a provision in the Assembly bill that preempts when there is a conflict between mining law and other laws of the state or rules of the state. It says the mining law will preempt. In Minnesota, there is a provision that says if there is a conflict between mining requirements and in other environmental requirements, the most restrictive requirement applies. In other words, they don't create exemptions for mining projects in Minnesota from other projects. But that's not what the Assembly did. The Assembly bill was trying to carve out certain kinds of exemptions, specifically for the mining, this particular mine. Let me read a few. I read you what the company publicly asked for. Then I reminded the governor, our plan addresses the goals stated by the company. However, nowhere in their advertisement did the company ask for provisions that would significantly alter environmental policy. They did not ask for permission to fill streams or ponds and mitigate the damage elsewhere in the state. Now that's a very important provision because in the Assembly bill, it allows the company to fill in streams. I don't think they're going to fill in a river, but they're going to fill in intermittent streams and then want to make it up by mitigating it somewhere else. So they go to the Bad River watershed, they fill in a stream. I don't know where the water is going to go. They fill in the stream, which is considered a navigable water, and maybe they come down and do a little dredging in the Yellow River or something. It doesn't make any sense at all. Not only doesn't it make any sense, it's unconstitutional. In our Constitution, the public trust doctrine states that the waters of the state belong to the people of the state. And that means navigable waters cannot be filled in or abused in any fashion because they belong to the people of the state. If this provision were to stay in effect, this law would be litigated at some point, in which it might stay in court for 7 or 8 years, which is contrary to the whole notion of coming up with a proposal that streamlines a process. Again, they never asked for that. They never publicly asked for it. They did not ask for permission to violate water quality standards an extra quarter mile from the existing mine boundary. Most people do not realize that the Assembly bill would allow the company, would not only allow the company, would require the Department of Natural Resources to extend what is called a contamination zone, which currently runs a quarter of a mile from the boundary of the mine, runs a quarter of a mile. It would allow them to extend that another quarter of a mile, completely around the mine, if they showed that they couldn't contain contamination at the first quarter mile, but they could contain it at the second quarter of a mile. Now this is a company that said that they were going to be able to use this clean technology and that they didn't have to change environmental policy. Minnesota doesn't allow for those kinds of conditions to exist. Now they couldn't, in all fairness, they wouldn't be able to go beyond their boundaries. But if you're a person who lives 1,500 feet from that outer boundary, how comfortable are you going to be that your lifetime dream home that you're retiring in is now 1,500 feet from a point where the company says we had to extend the boundary because we couldn't control the groundwater flow up to this point. And so that was an issue. They did not seek changes to limit the DNR's ability to monitor groundwater contamination beneath the mine. They're actually looking for an exemption that if this mine goes to 1,000 feet, they're not responsible for any damage, contamination lower than 1,000 feet. Now, if they spill something, they are, because the spills law would apply. But the point is that they don't need to do that. They should be responsible for making sure that there is no adverse impact as a result of their activities. They did not ask for language allowing mining and prospecting in state natural areas. I've never understood why the Assembly bill includes this. there is no state natural area in the Pinocchio Hills. So why would there be a provision in there that says that there cannot be mining in a state natural area? There is state natural areas in the Baraboo Hills where there is iron ore. And the people in the Baraboo Hills area have a right to understand why the law is going to be changed that may allow for mining to go in an area that's currently designated as a natural area, or might be designated as a natural area. They did not ask for a mining exemption for a contested case procedure in order to limit the rights of citizens to challenge a mining permit. Very frankly, that is one of the main differences between Senator Schultz and my bipartisan proposal and the Assembly proposal. Under current law, if almost every major water permit, there is a procedure, there's a public hearing in which people testify more from the heart than anything. Those become emotional testimony, some scientific. And then there's a contested case procedure whereby individuals can cross-examine DNR staff and or company staff to get an on-the-record, legal record on the issues that are being contested on the permit. And the idea is to let citizens use science to determine the eventual outcome of the permit. I want to ask the question, now you don't need to raise your hands, if you have a law that says that the contested case, a procedure for citizens to essentially go before on-the-record hearing, exists in the state of Wisconsin for a landfill, which it does, then why should we provide an exemption that prohibits the very same people from doing it with a 1,000-foot hole in the ground? And I've never gotten a good answer from anybody as to why we should have an exemption for only a mine, but no other water permits. And that was one of the issues that was raised. And finally, they did not ask for authority to strip away local governments of their ability to elect their own floodplain zones. There is a provision in here that says that a community can't have a floodplain zoning any more restrictive than the state. Now remember that in the last election, the issue was we need smaller government, not bigger government. This is an example where bigger government is telling smaller government they don't know what's good for them. And if you look at the frac sand expansion in this part of the state, more south of us in Barron County, you realize that what's happening in those communities are there's conflict between people who live there. And they depend upon their local zoning, they depend upon their local officials to set up provisions that will protect them. These mining companies want blanket authority to go in and do what they want. And so that was one of the provisions that was included in the Assembly bill that I don't feel was defensible.